Obviously, thank you very much, thank you. So obviously in a market that's growing so rapidly at the moment, there's some serious expansion within this industry, blockchain, cryptocurrencies. And a topic that always comes up that seems to be sort of sensitive, if you like, is always around regulation and everything that comes within that. If you've seen in the past, on a number of occasions where we've had news hit the wires, people talking about regulation such as the SEC or even central banks saying we need to put parameters or rules in place to regulate cryptocurrency, the markets have reacted negatively initially on the back of that. You know, we've seen Bitcoin, as an example, coming under pressure. But this isn't a bad thing, guys. It isn't a bad thing at all. Bringing in regulation and rules around the industry is only going to further help legitimize it. So it should really be seen as a positive. So on that note, we are going to have a panel discussing sort of legal, compliance and regulation. So a part of that panel, we will be welcoming Daniel Nathan, Susan Grafton, Alison Sheely and Ken Joseph and Simona Mola. So can we please put our hands together for this panel?
Hello, everyone. I'm Alison Sheely, and I'm going to introduce my fellow panelists. First, we have Jeff Gorham. Dan Nathan. Ken Joseph. And Simona Mola. And we're each going to start out and just tell you a little bit about who we are and give you, as we're all lawyers, and we're going to give you each an example of a common misconception that we hear in the ICO space. Excuse me, I'm Alison Sheely. I'm an attorney at Shulman Rogers in Potomac, Maryland. My background is in both SEC enforcement, white-collar defense, and I spent 5 years as a senior trial attorney at the Commodity Futures Trading Commission. We've been working through the last couple of years, helping companies get their ICOs to market and helping individuals be compliant. One of the most common misconceptions that I have heard is people call me and they say, we want to get our ICO out now, we have to do it now before the government starts regulating, and that is not at all the case. Unfortunately, because there is no central regulator for cryptocurrencies, for tokens, all kinds of different government agencies have their fingers in the pot. So you have to deal with the SEC, the CFTC, the IRS, the Department of Justice, FinCEN, state regulators. There are tons of federal and state agencies that are involved, and then you need to be thinking about if you want to issue a compliant token or cryptocurrency. Jeff, can you tell us a little bit about yourself?
Yeah, my name is Jeff Gorham. I spent 5 years to start my legal career in private equity and financial institutions, and then moved to a large law firm where I helped start one of the largest cryptocurrency law practices at an AM 150 firm. My principal duties were helping companies through the ICO process from start to finish, different spots along the way, and I also worked a lot with Bitcoin ATM operators and kiosks. I think the biggest misconception I hear is that if I set up my entity overseas, I don't have to comply with US laws, which just really isn't the case. If a US consumer's eyes can see your website and they can see your white paper and your marketing materials, it's still subject to regulation under US laws. So I think that that's the most common misconception I hear.
Dan Nathan.
Good afternoon, everyone. My name is Dan Nathan. I'm a partner with the global law firm of Orrick, Harrington, and Sutcliffe. Prior to joining private practice, I spent most of my career in enforcement with the SEC, the CFTC, and FINRA, 3 regulators who take a pretty deep interest in the crypto world and have been doing a lot about it. In my practice now, I principally represent individuals and entities in enforcement investigations by those entities, as well as do white-collar work and also compliance consulting, and work heavily with crypto companies to come into compliance with their regulations. And along those lines, common misconception is that if you're not the issuer, if you're not the entity who is putting out the ICOs, and are involved in the world in some other capacity, then you have nothing to worry about. And as we've seen from cases, and as I'll talk about in my cases, the regulator's arm reaches very long and reaches to anybody who really touches on the world if they're not operating appropriately in that world.
Ken?
Hello, everyone. My name is Ken Joseph. I am now with the consulting firm, the global consulting firm of Duff & Phelps. I am the managing director there, as well as the head of the blockchain task force and the global leader of the firm's disputes practice. Prior to joining Duff & Phelps, I spent 21 years at the SEC. I left the SEC in December of 2017. And my most recent position at the SEC was as head of the investment management examination program for New York and New Jersey. Spent 5.5 years doing that, and then for 16 years before that, I held various positions in the enforcement division, investigating and prosecuting various violations of the federal securities laws. Common misconceptions, I'll quote Chairman Clayton from a speech that he gave. Merely calling a token a utility token or structuring it to provide some utility does not prevent a token from being a security. Again, it's a common misconception that many seem to hold.
And Simona?
Hi, my name is Simona Mola. I'm a former assistant director as a senior policy advisor at the SEC. During my tenure under Mary Jo White and Mary Shapiro, I oversaw many of the rules, economic analysis of the rules that I hope we can discuss today that ICO issuers can use in order to comply with the SEC. For example, regulation crowdfunding, Reg A, and Regulation D. Right now, I'm a manager at Bates White Economic Consultant, and I provide valuation services for cryptocurrencies. So we evaluate the fundamental value of cryptocurrency in the context of litigations. And a common misconception that I hear while I participate as a speaker in several conferences is that industry participants think that the only way to be compliant, so an ICO issuer can be compliant with security laws with the SEC if only can register the tokens with the SEC. That's not the only way, and fortunately, and I hope we can talk about other ways to be in compliance.
So today's panel is talking about the SEC and the securities issues related to cryptocurrencies, virtual currencies. There's another panel tomorrow afternoon that's going to talk about some of the other regulators and their roles in this space. But on the securities space, Jeff, can you tell us a little bit about when we're talking about a particular virtual currency, how can we determine whether or not it's a security?
Yeah, the prevailing test is from an old securities case called Howey. It's a 4-part test, and it breaks down like this. The first step is it has to be an investment of money or its equivalent. So is crypto money? Well, it depends on who you talk to. Is it money's equivalent? Can it be converted to money? Well, a lot of people have differing opinions on that, but I think that the SEC is satisfied that for the sake of the Howey test, it does pass the first step. The second step is it has to be a common enterprise. So that just basically means you and multiple people get money, pool money together for one purpose, for one stated purpose or one business effort. There also has to be an expectation of profits. Why pool your money with a bunch of people in a common enterprise if it's not going to make you money, right? I mean, I guess it could do good. You could have a nonprofit that does some sort of good foundational work, but most of the time you want to make some money off of it. And then the third is that profit has to be derived predominantly from the efforts of others. So you're relying on other people's efforts to produce that profit. So if you pass all 4 of those steps, sorry, but it's a security. It's an investment document or it's an investment contract. And so you fail that way, I guess, if you pass the Howey test, which I never quite understood that difference. But.
Right, so if a particular virtual currency does essentially fail, or you might say pass the Howey test, does fall under the Howey test and is a security, then you're going to have to deal with the securities laws, and as Simona will talk about a little bit later, there are a number of ways you can do that in a compliant manner. For the last year or so, a lot of entities have issued, issue's not the right word, but have created ICOs, have gone through the ICO process, and have said, hey, our token, our virtual currency, it's not a security, it's a utility token. When we're talking about a utility token, what exactly is it that makes a token a utility, a true utility, versus a security? Where does that fall in the Howey test, and what are the types of things that a token that isn't truly a utility token might look like, as opposed to an ICO that's strictly for the purpose of raising money?
Yeah, you know, as Chairman Clayton said it, and you know, as Ken quoted, it has to have more than just some utility. What does that mean? No one really knows right now, and that's been the wild ride we've been on for a while. It just has to have more than some utility, but utility really just has a purpose and it has a function. So if you're using it to hash certain metadata or transactions, as opposed to using it as a way to reap profits or to pool your money to reap profits. I think that the big deal right there is trying to extract the profit angle out and focus more on the actual function of how this works in the ecosystem. So whenever I advise ICO companies and whenever I'm looking at their white paper, and by the way, the SEC almost always cites to the white paper for issues. So don't think that your white paper is just purely a marketing piece that's outside of the SEC's jurisdiction. That they focus too much on the profit. And really the white paper needs to be a little more objective about the actual purpose and the function of the token, I think, to get around the security issue and the profit issue and just focus on, you know, things that has to do with the ecosystem rather than how much an investor could potentially make.
I definitely agree with that. We've helped entities bring tokens to the market, which we believe are utility tokens, and the token in itself has an actual use and a purpose within the company's business. It's not just for the purpose of raising funds for the company. It has a use. The consumers who are buying the tokens have a way to use it within the system, and if you took it away and if there were no secondary market for the token itself would still have value. And to me, that seems to be sort of the quintessential nature of what makes something utility, as opposed to, I'm buying this token in the hopes that it's going to go up in value and I'm going to make money off of it, and if it doesn't, oh wow. Dan, did you have a comment?
Yeah, well, I want to put Jeff on the spot because I know he knows this stuff. We hear all about the SAFT token idea. How does that solve the problem of having a utility token out there that is not necessarily considered a security? How does that structure solve a lot of problems? Yeah, so the SAFT, and if those of you aren't familiar with the SAFT program, it's a simple agreement for future tokens. This is what you will give a U.S. accredited investor or a non-U.S. investor to sort of do a pre-sale. And all this means is if our platform goes live, you will get the first tokens out of the Genesis block, and you're going to get a nice discount right now. But there's a lot of risk. So the way that's done is that document itself, the SAFT, is a security. And at my former firm, and now that I'm on my own, I'm doing this as well, is, you know, file a Form D. And Simona will talk a little bit more about that, but it's an exemption from a full public offering that you can do, just sort of targeted. And since that is an actual security itself, you can shift that away from talking about the tokens. The tokens will come later. Just the document right now, the SAFT, is a security itself. Okay, thanks.
Let's talk a little bit more about the SEC's position. Ken, as among our group, you're the most recent person to have worked at the SEC. What are some of the positions that you've seen the SEC take since you've left? And how is that affecting the marketplace?
So I think the whole coin offering, cryptocurrency issue started emerging. I would trace it back to sometime between August, September, October of last year. So there's not a whole lot of history behind the SEC's position, but they've been quite vocal on it. On one hand, Chairman Clayton has been pretty clear, and I'm going to paraphrase his position here on behalf of the agency, is that he's really never seen an ICO that doesn't have sufficient hallmarks, if you will, to be classified as a security. And if it is a security, then the whole host of ancillary obligations come along with that, registration or being exempt, we'll cover a little bit later on, the obligation to make full and fair disclosure about the risk and rewards, if you will, with regards to the investment and so on. I think more recently, there have been two sort of public statements, one by one of the newer commissioners on the commission, who has, again paraphrasing, I think advocated for letting the industry kind of grow and develop without too much of a burden of regulation on it, especially regulation that really hasn't been designed to deal with this particular type of asset. And then even more recently, a public statement by the Director of Corporation Finance, which essentially says that Ether and Bitcoins are not securities. I don't see any huge controversy in those positions, quite frankly, because Chairman Clayton's view is strictly related to digital assets, digital currency that is in the form of an offering, an investment under the Howey test, and not anything that is purely just being used as a currency.
Dan, as someone who's sort of been just watching the headlines, do those statements seem to contradict themselves? Or there are times when it seems like the SEC has gotten out a little bit ahead of itself and then tried to pull back? What's your view?
Yeah, I mean, the best answer is yes and no, which is what I like to give as responses.
That makes it clear.
That makes it clear. I mean, there is nuance. I mean, to the typical person on the street, you know, Bitcoin, ICOs, it's all one and the same. And to the extent you come out and say something like, well, I've never seen an ICO that's not a security, is that a way of taking every single thing we're talking about here at Harrah's this weekend, or this week, and saying, well, none of this is ever going to pass the SEC's muster without registration? I think we all know the answer is no. There are differences, and I think it's really notable that both the head of market regulation, Bill Hinman, and also I think the chairman probably also have come out and said that they're willing to say that Bitcoin and Ether are not securities. I mean, does that, before I resume,
Yeah.
let me turn back to Ken. And you said, it does strike me as remarkable that a regulator would come out and plainly permit these to be outside the jurisdiction.
Yeah, I mean, Bitcoin used as currency and Ether used as currency is not a security. I don't think there's any controversy there at all, and I don't interpret any of the prior statements to suggest otherwise. What I think the chairman from day one and other agency officials from day one have been quite clear on is that if you are engaged in an offering where there's an expectation of profit and you meet the other elements of the Howey test that was described earlier, then you're a security. It really doesn't matter what the underlying asset, if you will, is. You could be offering mangoes for that matter. It really doesn't matter.
Okay, but so Bill Hinman, the head of market reg, and I would commend everybody here to take a look, gave a very good speech in which he really quite clearly laid out the elements and said, look, we want to meet with you, and our law firm is meeting with the SEC on various matters, and to be able to present a possible structure and ask if this passes muster, and we take them at their word that they want to meet with us. So on one hand, he's saying yes. He's saying I think he can conceive of a structure that would not necessarily be a security. And you can call it an ICO or a version of an ICO. If that's the case, why did Chairman Clayton feel obliged to say he has not yet seen a structure that is not a security? I understand it's limited, the statement is limited by its terms, but words have meaning. It gives a suggestion that, and everybody read it to be this way, it gives a suggestion that he will never see one.
Yeah, unfortunately, I think this is a case of the early innovators maybe overreaching a bit. The 2017 series of offerings, I think the problem is is pretty much not fully resolved, but there's a lot more information and effort, I think, to be compliant in this space today. But there were a lot of fraudulent, questionable type activity in those early phases. And remember, the SEC's role is investor protection, first and foremost, capital formation as well, of course. But I don't see how the agency literally could have stood by when the elements of a securities offering are present and not take a sort of very vocal position in an effort to protect the investing public there. Again, if you parse Clayton's statements, it is in the context of a securities offering, nothing else. So just, if you read it very, very carefully, it's raising awareness of the fraudulent activity or allegedly fraudulent activity that the agency was observing in that time frame, and the fact that it was really bore the badges of what a typical securities offering would look like, regardless of what the underlying asset was.
Yeah, I think that from a practical standpoint, if you think about Chairman Clayton being the chairman of the SEC, if he said most or almost all cryptocurrencies he's seen or ICOs were securities, well, that's probably because they're looking at the big fish, right? They're going to look at the most egregious cases. His investigators on the ground level are going to find those and present those to him. So it makes sense that most of them that he has seen would be the most egregious cases.
And dare I say, it's not just an SEC issue. Look across, maybe globally, there have been some countries that have taken similar positions. Within the U.S., you know, there's activity on the IRS side, on the DOJ side, at the state level. So it's not an SEC extremist view, if you will. And again, the agency and I don't necessarily feel the need to defend anybody here, but, but the agency has a role to play in the financial markets. And its primary mission, in addition to capital formation, as I said, is investor protection. When a large percentage of ICOs fail within 4 months, 5 months or so of coming to market, and there have been some very high-profile losses in this space, the agency has to do something and raise awareness. I don't think it's an effort to stifle innovation or stifle creativity, but the message ought to be clear. If you're going to be involved in a securities offering, regardless of how you dress it up, regardless of what you call it, if it meets the judge-made interpretation, the 70-some-odd-year-old Howey test, if it meets that if it fits that criteria, you're in securities offerings land, and you're going to be dealing with the SEC and perhaps other regulators as well at the state level.
Yeah, and I think too that Allison will touch on tomorrow on another panel she's going to moderate tomorrow, is that, you know, if you have hard assets like diamonds or gold or silver that are regulated by the CFTC, you're going to mimic a commodity swap or a future, and so you could run afoul of those CFTC issues. I'm just planting that seed for you all to go tomorrow to her great panel that'll be happening tomorrow discussing those issues. But yeah.
Thank you. So, Simona, for someone who, realizing that the SEC's goal is investor protection, and that there are ways to do this in a compliant manner that aren't I mean, there's a stretch, right? Like a full IPO on one end, and there are things on the other end. If someone wants to issue a cryptocurrency, and they want to do it in a compliant way, and they want to do it in a way that is not as costly as a full IPO, how might they go about doing that?
Yes, so it is possible to issue an ICO in compliance with the security laws and not necessarily register the tokens and issue an IPO. So that's an alternative that not only is not the only one, but is now in many cases feasible. It's too costly, even for a traditional company, a startup. issue and pursuing an IPO is very costly. Not only the placement of the shares, in this case the tokens, is costly, but also the ongoing reporting cost, the compliance cost can be prohibitive. So that's the one extreme. But analyzing the alternative, so if an issuer doesn't register the tokens with the SEC, has to rely on an exemption from registration. So now there are, I think, three main well-suited exemption in this case. All three allows general solidization. In this case, I think of these three because these ICOs are offerings on the internet. So I'm thinking of regulation crowdfunding, Reg A, and Rule 506C of Regulation D. So now, in this order, because I mention it in this order because they allow an increasing amount of capital. So in regulation crowdfunding, the maximum offering size is $1.07 million. Reg A allows you to raise up to 20 in tier 1 and up to 50 million in tier 2. And then Rule 506C of Regulation D, where there is no limit. It's an unlimited amount. But going back to your trade-off between capital formation and protection, clearly, when the maximum capital offering size increases, you can expect increase in also investor protections. So now, I have to say that these are the three main, and when you look at the ICOs, for example, that have been completed in the last months, there's a great variation. So you don't see a typical ICO. You see ICOs that raise less than $1 million. You see the gigantic ICOs, more than $800 million. So on average, the size is about $25 to $30 million. So if we think of an average size ICOs, then the two possible exemptions, Reg A, Tier 2, and Reg D. Now, Reg A require qualification, so require form, require qualification, and the issue is, well, looking at the statistics, the qualification happens by the staff of the SEC happens 55% of the cases, and also it takes some time. But ICO issuers can raise again up to 50. They can 50 million. There's no restriction on resale, and they can reach out to non-accredited investors who are subject to investment limits. There is also, on the other hand, again on the investor protection side, some periodic disclosure requirements. Now, if we look at Reg D, in particular Rule 506 of Reg D, yes, so the unlimited capital, you can raise unlimited capital, but only from accredited investors. And tokens, in this case, are restricted on resale. In addition, there is no exemption from the 12G registration. In other words, if there is a moment where the number of holder records is higher than 2,000, then that triggers registration in the Rule 506C Reg D. So now, with all this in mind, I think the real question is, there are exemptions, there is ways to be in compliance, but are these exemptions suitable for the crypto world? There are issues in implementation because these exemptions have been designed not with the crypto world in mind. When some like crowdfunding or Reg D were the amendments to the amendments to Reg A were mandated by Jobs Act in 2012. The crypto world, there was no amount of Congress. So there are some issues like how do you verify the accredited investor status? How do you verify the investment limits? How do you count the number of holder records when investors can hold different wallets, for example, and with different addresses? So these are all hurdles that clearly the SEC has to think about it. And in my view, although I'm not there, but I think in my view, the SEC is taking some time. For some people, it's a long time. I understand they may be frustrating the wait, but I think on the other hand, it's also positive that the SEC is trying to understand these words. At the time when I was involved in crowdfunding, for example, we interviewed many market participants. And so I think the SEC is doing the same to understand what would work in this space.
So Ken, can you talk a little bit, because I know you've done some work on the custody and the verification issues. For someone who's creating a new token, a new cryptocurrency, what are the types of things they should be thinking about? And also for someone who's investing, what are the types of things they should be looking for?
Right. So just one follow-up to what Simona said. The mantra within the agency is every securities offering has to be registered or qualify for an exemption. And what I would advise folks who are active in this space is that as you innovate and as you come up with all of these creative ideas and so on, do so with one thing in mind, which is you're operating in a regulated environment. And I know there's a lot of noise with regards to who's regulating what and what the issues are and so on, but it's really a good opportunity to pause and figure out before you come to market with something whether you are in a regulated space or an unregulated space, and if you're regulated, what are all of the requirements that you need to comply with? Does it need to be registered? If the assets are being put into an investment fund of some kind, and especially like a hedge fund or something like that, how are you dealing with the custody issues? Safety of client assets. There are specific rules that the SEC has with regards to safety of client assets. What about cybersecurity issues? How do you protect against hacks that may steal what are client assets? How do you value these things? Because in the fund world, usually the managers get paid based on the value of the assets under management. Do you have a reliable source of determining the value of the assets that you're holding on behalf of clients? So a whole host of safety, security, valuation, in addition to registration issues that have to be addressed, and I would recommend that they be addressed up front as opposed to you do the offering and then you try to figure out how to become compliant.
And just to follow up on that, and I didn't tell you beforehand, so if you're not comfortable, Dan or someone else feel free to take it.
I'm not comfortable.
I'm never comfortable. And if we're talking about Bitcoin or Ether, which I think most people would agree is not a security, if you put that into a fund, a hedge fund or some other type of fund, and you start selling interest in that fund, does that then morph that investment into a security?
Yes, because the security interest there is not the currency. It's really the partnership interest in the fund that folks are investing in and holding. So the underlying asset there doesn't really matter. It's, you have a limited partnership interest in a fund, and that's a security. That's well-settled law.
And so then the entities who are operating those funds, they're also going to have to look at, are they subject to the rules for investment companies, for investment advisors?
Advisors, yep. Do you need to register as an investment advisor? Do you have the requisite number of investors, for example, that requires you then to be registered as a public fund, so to speak? Are you complying with the SEC's investment advisor rules, such as having a compliance officer in place, conducting annual reviews, auditing the funds, and the like?
Great. For those companies in the last year who may or may not have followed all of the rules, there have been a lot of cases already that are in the works or that have been filed. Dan, can you talk about some of the bigger cases that you've seen?
Sure, and when I talk about enforcement actions in history, I'm kind of the Debbie Downer of the crowd. But it's important to be aware of the types of actions out abroad and what the regulators are looking at. Ken said it very well. You're operating in a regulated environment. We're just talking about the SEC today, and again on the panel tomorrow, you'll all be talking about other ramifications. It sometimes feels like they're converging on you from all directions. There are so many different angles, and it's a case in which, you know, stepping back a little bit, an innovative product and a really groundbreaking innovation to our economy is something that nevertheless has to keep up, has to satisfy pre-existing regulations, and the application of the Howey test to it is apt, it works well, it's there, and it's being applied today, and it all kind of comes down to the fundamental reasons for the SEC and the securities laws and protection of investors. I'll give you kind of an overview of how the SEC chooses to bring cases, particularly in a new area, and it's true also of the CFTC, where we also both have spent time. In any new area of products or structures or anything like that, they'll approach it from sort of two different directions. If a matter does not involve fraud, if it does not involve potential abuse of customers, loss of funds, et cetera, they'll take a very deliberate approach. They'll try to develop the law in a very methodical, careful, conscientious way, because if they go too far in alleging violations of things like the registration requirements, they risk making bad law and it could upset their whole system. So we see that when there's not fraud involved, and the prime example is the 21A Dow report that came out in the middle of last year. And again, it's something I recommend everybody to look at if you haven't seen it. It lays out exactly what Jeff was talking about, why ICOs and many kinds of coins might be considered to be a security. I'll give away the answer on that one. It came out as a so-called report of investigation, not a enforcement action, because the company took steps right away to shut down what they were doing, to give back any funds that they'd raised, and try to do things the right way. And because it was a new area, the SEC felt it was a better opportunity, rather than to whack, the technical term is whack, rather than whack a company in enforcement proceeding across their head, instead, let's send out a message to the industry and the world, this is how things should be done. So that's in the non-fraud cases. In the fraud cases, there's a different issue involved here. We're talking about protection of investors, and that's where sort of the SEC's mama bear instinct kicks in, and they want to protect people. And the more serious the fraud, the more they're willing to bring a case quickly without necessarily having all the pieces in place as to the sort of philosophical, legal underpinnings of why they bring a case. They're hopeful that a judge, despite arguments against the case, the judge will see, look, there's individuals out there who've lost money, are losing money, let's bring the case and not worry too much about some of the legal niceties. The SEC is also hoping that they'll bring the case against people who may not be in the upper echelons of the financial industry, shall we say, who may not bring in the best lawyers and may not put up good legal arguments, which may be there, but they may not put up good legal defenses against them, and it'll enable the case to go. And on top of that, many of these cases are brought if there's still ongoing violations, which includes if you're still raising money, or if you've raised money through fraud and it has not yet been returned, that's considered an ongoing violation. So they'll bring cases looking for what's called emergency relief. They'll seek a temporary restraining order. They'll go in without giving notice. They'll file the case under seal, and they'll do it in a way to freeze evidence, prevent destruction of books and records, and freeze the funds in place before the maldoers have the chance to destroy these things. And in freezing up the funds, it also may limit their access to legal recourse. On the other hand, there's hope for all of us. If you go out in a non-fraud way, raise money, you've stubbed your toe against the registration requirements, against investment company requirements, other requirements. If you show right away that maybe you're ill-advised or you didn't consider everything, you shut it down, you return the money, you put out corrective disclosure, and you agree to what the SEC wants you to do, they'll go easier on you. It's called mitigation, and the rolls are filled with cases in which mitigation has been shown and recognized by the SEC. Let me tell you about the kinds of cases that have been brought so far. There's been about a dozen, I think, rough count, over the last 4 or 5 years. They fall into 3 categories. The first is sort of the Dow type case, and there may be 1 or 2 others in which, in the absence of fraud, the SEC has been willing to come out and say, this is a security, you failed to register, and we're going to take the leap and give the analysis about why it violates Section 5, and we're going to shut it down. That's kind of taking the biggest leap on their part, because it's really developing the law of registration. The second kind has that plus fraud. And those are the cases I described, in which they often want to jump in, freeze everything up, and try to get a TRO, and they'll also throw in a registration violation as well. The third kind are not really ICO cases at all. They're sort of more traditional cases, basically offering fraud. Basically, you've sold securities either without registering them or unregistered securities through an exemption, but you have either kept the money, not returned it, you've put out false disclosures. Why do I raise those? Because there's some connection to the blockchain crypto world. It could be that you have a company that is you've sold traditional securities, but the company went ahead and purchased a crypto company, and that they made a big announcement about it. It enhanced the value of the company's stock. Or it's a company, you sold securities in it, and they bought a bunch of Bitcoin. Or you invested in the company because they have mining technology, and you were investing on the premise, or the premise and promise of them mining, finding coin, and the value of the company, after you've mined and created more Bitcoin, the value of the company is going to go up. Or it could just be a fund that invests in a lot of it. And those are basically the 3 categories of cases. I'm not sure I'll go over and identify them individually, because there are many of them, and it'll take me probably until pool time. So, but those are general categories of case.
But one thing that I think it may not have occurred to some individuals, if you're creating an ICO, you're issuing a cryptocurrency, you've done it in a way that's maybe not compliant. Either you failed to register, you failed to qualify for an exemption, or you've engaged in fraud. If the SEC comes in, they file their complaint, they file it under seal, they get a TRO, it freezes books and records, it freezes assets. I think a lot of people think, well, it's just the company. It's just the company and the money that's in the company that's at risk. Can the individuals who have been working on this, can their own personal assets also be frozen?
Absolutely. And the trend in law enforcement for at least 10 years or 15 has been to go after the individuals, because entities only work through individuals, and you can shut down an entity and the individuals can go down the block and open a new entity somewhere. We know from our time at the CFTC that there are individuals going from one Forex scam to another, open new shops, and do the same thing. So they want to go after the individuals involved. On top of that, like, as I said earlier in my misconception, it's not just the issuer who's a risk here. Some of the cases have been brought against exchanges that have been set up in order to allow people to buy or sell, and they should have been registered themselves under the securities laws as exchanges, or as brokers, or as transfer agents, something like that.
Yeah, I'll just add to that the agency has announced an initiative, if you will, to hold gatekeepers responsible. So it's not just the issuers, it could be the lawyers, it could be the accountants, it could be whomever could be fairly classified as a gatekeeper, either for direct liability or indirect liability, aiding and abetting the violations by the issuer in this case. I'd also add that my view on the cases that have been brought, it's almost irrelevant that it involves a digital asset or a coin or something like that. It's really your garden variety misappropriation, misrepresentation, Ponzi schemes, failure to disclose, making outlandish promises, failure to register, things like that, which again you can apply to almost every asset class and almost every type of allegedly fraudulent activity that the Commission has pursued.
Yeah, the underlying Bitcoin assets, whatever it is, those are the widgets. Those are the things you have to disclose accurately about. If you're raising money to make bicycles and they happen to have no spokes, that's a problem. if you're raising money in order to purchase Bitcoin, or one of the cases involves a real estate related token, and the claims were made that we have an army of lawyers, real estate brokers, accountants helping us do our real estate transactions and base a token on it, and none of it was true. We didn't have any of it.
Yeah, I think just to reiterate something that I said before, you're in regulated space, and I also believe that you need to pay attention from the get-go. Anytime you're making a public statement, it can't just be based on aspirational goals. It has to be based on fact. So I aspire to rule the world, but if I am making a securities offering on Ken Joseph, I can't represent myself as the ruler of the world. That would not be true at the moment that we engage in the offering of Ken Joseph as a security.
Yeah. And let me get back to one of the things that Ken said, and this is one of the smart things that, even though I don't like it, but that Chairman Clayton did, was say we're going to also look at the lawyers as gatekeepers. We're going to take a close look at them, because once you talk about lawyers, that hits home with us. It's saying we're not just going to give advice off the tops of our heads. We are at great risk if we give the wrong advice. They're going to look at us as well. And you start with the lawyers, it helps keep the rest of the industry clean.
And I think, there have been about a dozen or so cases that have been filed so far, but there are more coming. We learned back in, I think, February and late January that the SEC had issued more than 80 subpoenas. And those subpoenas went to the companies that were selling and operating the ICOs. They went to the advisory firms. They went to the hedge funds and the other funds that were including cryptocurrencies and digital assets within their portfolio. It went to the lawyers, it went to other gatekeepers, and it went to the exchanges. And so I think we're going to see, it takes a while, they've requested a ton of data, we're going to see a lot of actions come out of that. So, some of the data that they've requested include the marketing materials that were used for the ICO, the identity of the investors, investor list. Where are the investors? Where do they live? How much did each person invest? How much money was raised during the ICO? What were your emails and your other communications regarding the launch of the ICO? Where are the funds currently located? And where are the people involved? The people who are running the ICO, the people who are doing your marketing? Where are all of these people located? I think we mentioned it earlier, that I think Jeff had mentioned it as a misconception, that people think, oh, well, we're creating this ICO, but our entity, it's formed in Estonia, or it's formed in the Cayman Islands, and the entity is all over there, so we're not subject to U.S. jurisdiction. That is not the case. If you are selling to U.S. people, and you're not preventing U.S. people from reviewing your marketing materials, you are more than likely subject to jurisdiction in connection with an ICO.
Yeah. I'll just say that it doesn't depend on whether a sale has occurred. The mere offering of the security to U.S. persons brings you within the scope, if you will.
Simona?
Sorry.
Yes, so in particular, for example, if an ICO is offered to non-U.S. person, they have to comply with Regulation S. And also, they have to separate the domestic offering from the non-U.S. offering. And the issuer has to make sure to that complies with the prohibition of non-U.S. person to resell tokens to U.S. person. So it's a challenging to enforce also this compliance, and so makes it even harder.
I just wanted to jump in for a moment, is that it's always been my philosophy of wherever you have your consumers, that's where you should set up. I have seen a lot of ICOs that set up overseas, and they say, we will not sell to U.S. investors. By purchasing our token, you represent to us that you are not a U.S. investor. But darn it if they didn't do any geofencing, if there's maps of the United States in their slide deck or their white paper, and they're pricing everything in the U.S. dollar. I mean, this is, you're not fooling anyone. And the more you try to make it look like you're evading U.S. law, the harder the regulators are going to come after you, I think.
We have focused a lot on regulation at the federal level. I don't want to ignore the other jurisdictions that may be involved here as well, including at the state level.
Yes.
And we talked about registration and valuation and custody concerns. We shouldn't ignore the AML concerns as well, the anti-money laundering, terrorist financing type concerns as well. So
yeah, I think that tomorrow we'll have a panel that dives deeper into that, but there are also state securities commissioners that regulate securities on what we call blue sky laws, which are just the fancy lawyer slang for the state securities laws. State attorneys general, focus on consumer protection, and then the securities regulators focus on the security side. As he mentioned just shortly ago, the Bank Secrecy Act still rules a lot of conduct in this area. And again, back to, I think if you can sum it up, this panel, the thing that you should take away is it's not the thing that's being regulated, but it's the conduct around the thing. And that's what you've got to focus on. I know that a lot of people have been all up in arms about regulating cryptocurrency. How can this be? Well, any of the decisions that I've read from the SEC, I've read through them, I thought, yeah, that sounds about right. I mean, that's like what I walk away from is it sounds like a sound application of current laws. Yeah, the duck test. If it walks like a duck and quacks like a duck, it's probably a duck.
Yeah, so I think the subpoenas that have gone out and the investigations that are likely to come in the future are going to focus on fraud, they're going to focus on registration issues, and you should be aware that the SEC, if you get one of those subpoenas, you're going to get a document with it that has all of the uses of the information. The SEC shares that information frequently with other regulators. That includes the CFTC, it includes the Department of Justice, and it also can include the IRS.
And I'll say that, I've worked with some entities that saw the SEC's subpoenas several months ago on, specifically they were looking at the SAFT program. Yeah. And in discussions with the regulators, it seemed to me one of the takeaways I saw was that they were really trying to understand how it worked. And it just sort of made me grin. I was like, well, they really do want to know how this stuff works. They're not just blindly making law based on assumptions and misconceptions. They're actually trying to get a look under the hood and see what we do and how these things operate. So I think that really, if you compare us to other jurisdictions, sure, there's regulation, but rather than being the wild, wild west where anybody can start an ICO, there's some barriers to entry, but we're not in an all-out ban, and I doubt we ever will be.
And also, can I add only one last thing?
Last comment for Simona.
So I think also the position of SEC is, it's not like some of other regulators, like for example in China or South Korea that have banned ICOs completely. I think again, SEC is trying to understand, but also is trying to perform its role of financial educator. So I think you saw the fake site, how it coins that alerts investors of the risk related to ICOs, or some of the ICOs. So that's something to, again, part of financial education for investors.
Thank you.
We'll congregate out back, I think, probably,
right? Yeah, if
right?
you have questions, we'll be out in the hallway, but I hope to see some of you tomorrow at tomorrow's panel, which focuses on other government regulators. Thank you.
Thanks.